Alabama has a new revenge porn law. And what this law is designed to do is to protect people from having images that they expect to be private from being published in a public sphere, most likely the internet. So, for example, Sally and Bob are dating. Bob says, "Hey, Sally, send me a picture of your coconuts." And she sends him a naked selfie. A little while later, Sally and Bob break up. Bob says, I'll get even with her. I'm putting this picture on the internet. I'm putting it on Facebook or wherever for everybody to see. Well, she's mortified. She meant for only him to see it. He has now committed a crime, and the crime he's committed is basically revenge porn. The reason he's committed the crime is that image, I call it the for your eyes only test, that image was meant for his eyes only. She had a reasonable expectation of privacy, assuming that can be proved. She had a reasonable expectation that image was only to be seen by him and not others. And if that's true, he could be convicted. He could spend up to a year in jail for the first offense. Now, if Bob's an idiot and after being convicted has another girlfriend, Jane, and he does the same thing again, breaks up with Jane, puts her pictures up, now he's looking at 10 years in prison. And of course, Bob's an idiot if he does that, but that's a different story. Now, there are defenses to the crime of revenge porn. It's actually called publishing a private image and some other things. I'll reference it below. One defense, of course, is that the person didn't have a reasonable expectation of privacy. Let's say, I don't know, the I Want to Feel a Thigh fraternity hires a stripper to jump out of a cake. And she jumps out of the cake and poses with all these young lads. They're all there taking a bunch of drunken photos with this stripper. And they all put it up on the frat website, which is available to everybody, of this girl in her various state of undress. She gets upset. She goes to the DA and says, "Hey, they published images of me naked and I'm embarrassed." Well, the DA may say to her, "Lady, you don't got a case because you didn't have a reasonable expectation of privacy under those circumstances. You knew they were there. You knew they were taking pictures. It's a whole frat. Everybody was invited." So in those circumstances, that would probably be a defense. It may not even come to a case. If it was a case, his defense lawyer would probably jump up and say, "Come on, ladies and gentlemen. There was no reasonable expectation of privacy. She was a stripper letting them take pictures. She knew they were going to do this. Come on, it's ridiculous." Whether or not a jury would buy that, that's a different issue. Now, there's other defenses. One of the defenses is that the photographs were taken either for medical purposes or for law enforcement purposes. For example, I had a case where there was an issue where it was an assault. The woman got bit on her breast. Teeth marks were on the breasts. If those teeth marks are used for identification, then that's not publishing a private image if it's used for law enforcement purposes. Another case, really disgusting case, where it was a rape case. The rapist had the words "bitch switch" tattooed on his privates. Again, the woman, her identification of her rapist was, hey, it said that on his privates. That image was used for law enforcement. There's an exception there. Also an exception if it's used for medical diagnosis. So there are some exceptions built into the statute. There's other things that will depend on lawyers' creativity. I suppose one of them is going to be, well, you can't identify this person. The photograph's blurry or it cuts off the head or whatever. So we'll see as time develops. It's a new statute. We'll see what's what. Now, another very, very important issue is this a sex crime? And the answer is, it's not that clear. Alabama law says that any criminal offense can be a sexual crime if the prosecutor elects to make it a sex crime, to accuse it as a sex crime, but he has to prove that the crime was done with sexual purposes. So, for example, if somebody burglarizes a house, well, normally that's not a sexual offense. But if the guy's burglarizing it, and this is a real case I had, and the guy's stealing nothing but ladies' underwear, it's probably a sexual crime, and the prosecutor can assert that the crime was done with sexual motivation. And if the jury believes that, that crime can be made into a sex crime. And if a crime is made into a sex crime, the Alabama sex offender registration and notification provisions kick in and apply. Now, whether or not that will happen for this specific offense, time will tell. At any rate, I hope you find these videos to be educational and informative. If you're in a legal jam, If you're accused of anything, of course, you're wise to talk to an attorney. If you want our help, just give us a call. The information's below. I'm Andy Siegel. I hope you enjoyed this video. Thank you for watching.